Common questions, folks, right here. Who should serve as my trustee? I get this question a lot. Who should serve as my trustee of my irrevocable Medicaid Asset Protection Trust? And I often say to our clients is, you're the expert on the family, or your attorney should be the expert on the law. And the deal is, you teach your attorney about your family and the family dynamics, and the attorney will teach you about the law. You work together to co-create and customize your plan to meet your dream snapshot. So when you are up in your cloud someday, looking down at your loved ones, everybody's happy. They're all looking up at you, singing your praise, getting along. Compared to the backside of the cloud, where everybody's fighting, suing one another, rain, lightning, thunderstorms. You don't want to be on the backside of the cloud. I often say to my clients, you want treasure chest, not the ugly milk crate, okay? So who should serve as your trustee? Here in Massachusetts, Medicaid is very strict. Mass Health is very conservative and strict. Why? Because Medicaid makes up about 20% of the Commonwealth's budget, from my understanding. And that's a big concern for the Commonwealth, and you gotta make sure that they're protecting the Commonwealth's budget and so forth. And so they gotta make sure that they're scrutinizing anyone applying for Medicaid. In Massachusetts, there's some case law where if you, the trust maker, are creating your Medicaid trust, you should not serve as trustee manager of it as well. Why? Because you'd have two things, control and authority. And if you have too much control and authority over your Medicaid trust, it's typically not going to work under current law. So the recommendation in the industry for us is to advise our clients for them to choose a trusted family member. Could be your son, could be your daughter, and only you know who is the best candidate in your family. Who is most suitable? Who do you trust in unconditionally? So if you say to your daughter or your son, jump, you want them replying, how high, mom and dad? And that might be a good candidate, but you also want to make sure that they have the proper business acumen as well. So trustee, who should serve? That's really your choice. And it's really a counseling issue that you should work on with your attorney, but it could be your son or daughter. From my experience, majority of the time, our clients pick a trusted child to serve as their trustee manager. But folks, you want your number one pick, you want your Tom Brady, and you want a backup, successor, alternate trustee as well. Just in case the number one trustee runs into times of turmoil or they can't serve for any reason whatsoever, you want your backup stepping up into their shoes day number one to manage that trust for you. Okay, really, really important. Another consideration, some folks look to professional third-party trustees as well, a bank, a CPA, a professional trustee company. That might make sense if you have a very large estate because that'll cost you as well. But again, it's a counseling issue. Work with your qualified attorney on what may be the best fit for your family dynamics, okay? But I'll leave it with this part right here. Oftentimes, don't get stuck because you don't know who the best trustee would be. I often say to my clients, your worst pick is often better than the probate court's best guess, okay? So don't sit on the sidelines and don't get paralysis by over-analysis, so to speak. Pick a child who you think is the best candidate, the most suitable, and put that child in place as your trusted trustee of your Medicaid trust, all right? How does the 5-year look-back period work, okay? So the 5-year look-back period works is, the example with Bill and Mary, Bill checked out first, and when Bill checked out in October of 2020 in our example, Bill has to stay healthy for at least 5 years before he ever fills out a Medicaid application, okay? So that's the period that Medicaid's looking at, the time you're filling out that application. They have the legal right to make inquiries of all your financial records going back 5 years in the past. So what they're looking for is gifts. If mom and dad were giving gifts out to the children, the grandchildren, big, large money gifts, cash gifts, that's going to create what they call a penalty period. And Mass Health's Medicaid's position is, hey, you don't qualify for Medicaid benefits because you were giving money away to your family. They will construe that typically as you were sheltering assets. You know, if not for you giving that money out, you would have this money to private pay. So why should the government give you money, right? So the 5-year period begins when you get your property into your Medicaid trust, and we do that by recording the deed at the county registry of deeds. That's when the 5-year clock begins to run. And we typically look to put real estate only in these Medicaid trusts because I call them a set it and forget it trust, okay? Meaning what you set in there, you have to kind of forget about. And real estate makes a good, clean asset because you can still reside in the home, live in the home. I typically advise clients not to put cash in there unless you never have to touch that cash ever again. And most of my clients are not in that position. They need to still touch their cash, use their cash for their use and enjoyment as a journey through life. So the cash may not be protected from the fourth-headed monster, estate planning right here. Fourth-headed monster is Mass Health Medicaid in this scenario. And so the cash may not be protected unless you put the cash in the Medicaid trust. Can you put the cash in the Medicaid trust? Answer is yes, so long as you know that you can't touch it. If you start pulling cash out of that Medicaid trust, it's not going to work. Hence the reason why we typically advise clients, put your real estate only in there unless you're truly sure that you're not going to need a chunk of cash. And sometimes folks might put a chunk of cash in there if they're pretty well off and they have a good stream of income coming in. Before you do that though, work with your attorney, work with your financial people and your accountant to make sure that you're not putting cash in there that you may need for an emergency someday. Okay, take the conservative approach on that, folks. All right, so how does the 5-year look back period work? You got to get that clock started before you ever fill out that Medicaid application. 5 years from the date you got that clock started to the date that you're filling out that Medicaid application. All right, anything in between is not going to work, okay? All right, can I sell my home is a common question. Answer is yes, but you need the cooperation of your trusted trustee. Hence the reason why I said pick someone that you trust unconditionally, your son or your daughter or someone else in the family who you can trust unconditionally. Hey, mom and dad want to sell the house, we're downsizing. They need to sign that deed, okay? They need to sign that deed, they need to cooperate. So you need to pick someone that you feel is suitable. Also, you want to make sure that you don't touch the money and you're not involved in those business transactions. You're not signing purchase and sale agreements or offer to sell agreements and so forth, because now you're showing that you have control and authority, and the trust is not going to work that way. You have to trust your trusted trustee to handle those matters for you. And again, work with your qualified attorney that will guide you through that process. As far as selling your house, can I refinance my home? So that's typically answer is no, okay? Typically you cannot refinance your home when the property is already in the irrevocable Medicaid trust. Banks typically do not like to loan money to a property that's in trust because the bank wants to ensure that if the homeowner stops paying their mortgage, the bank can foreclose and take back the home as collateral, right? So irrevocable trust makes a bank very concerned. They'll typically ask you to take the property out of trust, get your loan, and they may let you put it back in trust with your authorization, okay? But that being said, the problem or the downside to that, folks, is when you take the property out of that irrevocable trust, you're going to be resetting the clock. So let's use our friends Bill and Mary. They started the clock running. They created their Medicaid trust in October 2020. They deeded the property into the Medicaid trust in October 2020. 5 years, look back period. Let's say they get 3 years into it. October 2023, 3 years into it, and they're like, okay, we want to pull some cash equity out of the property, and the bank says, okay, you need to take the property out of trust. They take the property out of trust, put it in their names individually, they get their loan from the bank, they're happy, but that's going to reset the clock for them. And as their agent in place, they may not have the luxury or opportunity to make up that 5 years later if their health continues to decline. So be very, very careful with that. Be sure that you don't need to borrow any more money, and that's something you need to assess with your professional team. And if you do need to borrow money, then I would recommend borrow that money first. You can still create your Medicaid trust, but don't transfer the property in there until you receive your money, okay? And it's always good practice to get authorization and permission from your lender when you're doing that, okay? There's some laws out there, the Garden-St. Germain Act, that will allow a homeowner to put their property in trust. But again, on that mortgage statement, it typically will say that if a homeowner changes the title to their property, you need to get authorization from the bank, because the bank can accelerate the payment. They can call you and say, you got to pay up, you got to pay the whole mortgage now. And you don't want to run into that situation. So keep in good relations with your lender, with your bank. Can I sell and downsize my home? Yeah, we talked about that. So oftentimes, folks will get the 5 year clock running. They'll be 2 or 3 years into it. Now they want to downsize. And can they do that? Yes, you need your trusted trustee to sell the house, sign the deed, sign the purchase and sale agreement. You need to keep your hands off because the trust owns the property. You don't own the property. You relinquish control to your trustee and your trust, right? And that's how you protect from Mass Health Medicaid. You relinquish control. You're protecting from the government. So you have to give up. That's why I call it a set it and forget it trust. And in this situation, your trusted trustee can receive the sale proceeds from your house if you sell it for $600,000 and you're buying a new home for $400,000, you're downsizing. You take the title to the new property day number one in the name of your family's Medicaid trust, okay? And if it's done properly under current law, there should be continuity there where you can resume that 5-year walk out into the future, okay? Where you're not risking resetting that clock. Again, work with your qualified attorney and let them guide you on how to best do that, okay? All right, there are common questions out there, folks. All right, so that's move on to Medicaid crisis planning. And we talked about at the beginning of this program, on part 3 of the program, there's 2 types. There's pre-planning and there's Medicaid crisis planning. You always, in my opinion, want to do the pre-planning because you have the opportunity to protect the most amount of assets, and typically the legal cost to do that is going to be much less than doing the crisis planning, okay? Crisis planning is when clients or folks didn't do adequate planning, and now Bill and Mary are, one of them is completely incapacitated, and the family's writing out that $12,000 to $15,000 per month check to the nursing home. And the doctors are saying, well, their diagnosis is pretty good other than maybe the dementia or their disability. They might be able to live for a long period of time. And the family's running the numbers, $15,000 a month over 36 months. They're saying if our loved one lives for 3 years, we're going to be private paying at $15,000 per month over 36 months, $540,000. That's going to leave Mary, the community spouse, impoverished, indigent. That's going to completely change her lifestyle, and that's typically not a good situation for the entire family. So Medicaid crisis planning is a alternative when Medicaid pre-planning wasn't done adequately or not done at all. But let's talk about Medicaid crisis planning and how some strategies may work, okay? So the goal for Medicaid crisis planning is different than pre-planning. Pre-planning goal is to protect the assets when you're alive and well and beat that 5-year clock, okay? That's the key right there. When to do it, maybe 65 years of age, but it's a counseling issue, sometimes a little bit earlier. But if you're beyond 65, you want to get that clock running, in my opinion. Goal here is different. The goal here is to eliminate assets with proper spending down of your assets, because you're looking to qualify for Medicaid benefits at this point in time. Because Bill will say is got 1 foot in the nursing home or already both feet in the nursing home. Families writing that big check each and every month, from my experience, pretty painful for the family. And they're looking for answers. How can we protect some assets? How can we possibly get on Medicaid? How can we make life more affordable and comfortable for Mary, the mom at home? So different strategy and different goal. Eliminating assets with proper spend downs when you're alive and not so well, which is disability. So Medicaid compliant annuity is one strategy, one viable strategy that is currently permissible under current Medicaid law. So Medicaid compliant annuity, we'll call it MCA, and we'll talk about that. Medicaid compliant annuity, folks, is converting excess assets into an income stream. Converting excess assets into an income stream, either for the institutional spouse or the community spouse at home. And a Medicaid compliant annuity is called a single premium immediate annuity, or in the industry, if you have any experience with this, or in the future, if either you or your spouse or a family member becomes completely incapacitated, you might hear the professionals, the insurance professionals, the financial people, or your elder law attorney referring to a SPIA, S-P-I-A, which is simply a single premium immediate annuity. Okay, again, it's an investment, converting your assets into a Medicaid compliant annuity, changing an asset because you're over asset, you can't get bill on Medicaid. You're converting that asset into a Medicaid compliant annuity, and it's converting it from an asset to what they call an income stream, which is okay and permissible under current Medicaid laws. Under the DRA, or the Deficit Reduction Act, it's permissible under current law, okay? Another strategy here for long-term care Medicaid crisis planning is what they call a pooled trust. Pooled trust is the code US 42 1396 D4C is the code under the Internal Revenue Code, but the pooled trust is a way that you can also shelter or safe harbor assets, okay? We've been able to help families in the past when they were in excess assets and they're looking to get a loved one on Medicaid benefits, but they're over asset. So in comes the pooled trust. Pooled trust is typically a nonprofit organization that will manage the money, the excess money, and pay for what they call extras, okay? Extras in life for the incapacitated person, okay? So the pooled trust money will pay for extras, while the Medicaid money will pay for needs-based care. Just a little history on pooled trust. Pooled trust, from my understanding, was created by the legislature for special needs folks that were born with disabilities. And later in life, when their parents passed away, their parents were leaving their special needs child or children the home, life insurance, cash assets, okay? That was their inheritance. But now the special needs child or now special needs adult is receiving government means tested benefits. They could be receiving food stamps, housing, medical care under Mass Health, Medicaid. And now they receive an inheritance from their parents. That's going to put them over asset, okay? They typically can't have more than $2,000 in their name. It's going to put them over asset. Two bad things could happen. Number one, it's going to knock them off their benefits and have to reapply all over again. And number two, they may have to start private paying until they get back on those benefits, okay? So pooled trust was created for special needs folks. However, state elder law attorneys were able to use that law also to assist folks aging in place with dementia and Alzheimer's and other afflictions happening to aging seniors who needed to go into a nursing home, able to assist that person shelter their excess assets in a pooled trust, okay? So it's another strategy. I call it another tool in the Medicaid crisis planning toolbox. You have two of them. There's more than two, but from my experience, these two have worked relatively well here in the Commonwealth, in Massachusetts. Other states have other Medicaid crisis planning strategies, but you want to work with a specific attorney in that specific state, in that jurisdiction, who's familiar with the Medicaid laws in that state and in that jurisdiction. Really, really important. Again, folks, because Medicaid is a federal program, however, it's administered by the states. Each state has their own little rules, their own little nuances. You really need to work with a qualified, experienced attorney in the state that you're going to be looking for these benefits or the state that you reside. Really, really important. So, Medicaid compliant annuity, SPIA, and pooled trust. Turn the page here. Let's do an example here. We have our friends Bill and Mary, okay? Bill's 75, Mary's 73, okay? Bill and Mary want to do some pre-planning. We talked about that a few slides ago, a few sheets back. Bill and Mary create their trust, their treasure chest, okay? When they're alive and well, they get their home into their trust, okay? Because that's step two of the process. Step one is creating your trust or treasure chest. Step two, get your asset or assets in there. In this case, we're talking about Medicaid trust. So house only would be my recommendation in this example. You want to work with your qualified elder law attorney for your particular circumstances. There's no one size shoe fits all in estate planning, okay? So you want to get that 5-year clock running, and Bill and Mary did that. They did pre-planning. They got the family home into the Medicaid trust, and they're looking at beating that 5-year clock, staying alive and well and unincapacitated, okay? But in this situation here, say before they get to the 5-year look-back period, Bill has a stroke. He's completely incapacitated. Wife Mary can no longer take care of Bill at home any longer. So Bill is incapacitated and needs to get on Medicaid benefits. How are they going to do this, okay? So we're going to have to do an assessment of Bill and Mary's assets, okay? So here we are. So Bill's health is poor. He had a stroke, okay? He can't be cared for at home any longer. Like my dear dad many years ago, it wasn't safe for him to go home because he was considered a fall risk. And it wasn't safe for my mom to take care of him at home any longer because the two of them could have fallen. And so my dad had to go into the rehab facility, and the slippery slope when you're not doing well and improving in the rehab facility, typically the slippery slope of life, nursing home is the next stop along that journey. So here's Bill. Bill started the journey. He's in poor health, okay? He has about $1,800 monthly income. That's important. We'll circle back to that later. Here's Mary. Mary's 73 years of age. Mary is in good health. She has about $1,500 a month in monthly income, okay? But here's her asset allocation right here. This is a outline of their assets. This is their home. Their home is worth $450,000. It's owned jointly by Bill and Mary. They also have a checking account held jointly, $50,000. Savings account is owned by Bill, $75,000. And then they have an automobile joint, $30,000. And then stocks, Mary, $75,000. And a CD, certificate of deposit at the bank, $150,000. And that's joint, okay? So that's all their assets. When you add everything up, they're kind of what I refer to as middle-class millionaires. They're about $800,000 plus. And they're in no means sitting on $1 million cash, but they have enough assets, like a lot of the folks that we work with who are concerned about sheltering and protecting and doing the 3 Ps, protecting, preserving, and passing down some of those assets to the spouse, to the children, to their Mo, Larry, and Curly's as a family legacy. All right, let's talk about steps that we can do here. Also, I have up here on the board is Revocable Asset Protection Trust. Typically, our clients will create what I call an irrevocable Medicaid Asset Protection Trust and put their home only in the Medicaid Asset Protection Trust because they want to get that 5-year clock running and protect the equity in their home. A lot of our clients, that's the largest asset they have. And they'll take their cash and they'll put that in a Revocable Asset Protection Trust because that way they can still control it, use it, and have the use and enjoyment and touch the cash. It won't protect it from Medicaid, but when the cash is in the Revocable Asset Protection Trust, it will protect from probate court, provided the trust was funded, retitled all the assets into the treasure chest. Number 2, if you have the proper tax planning language in there, you can minimize or reduce the estate tax to the greatest degree possible. And if you put the proper asset protection language in there, it will enhance the asset protection for the surviving spouse, for a separate trust, and for the Mo, Larry, and Curly's in a separate or joint trust, provided you have the proper asset protection language in your trust. The devil's in the details when it comes to asset protection language, like a lot of legal language. Again, work with a qualified estate elder law attorney who is experienced and can draft that proper language for you and your family. But I want to mention that there, a lot of folks will create both trusts. Let's turn the page here. What if Bill and Mary did nothing? What if they had a simple will, which, as you know, is typically woefully insufficient to properly protect your assets? There we go. Simple will, or even a trust that doesn't have the proper language in there, or a trust that's not funded. Typically, a will is your admission ticket to probate court. It's going to end up in the ugly milk crate, okay? End up in probate court and end up being probated for about 1.5 years, 2 years, sometimes longer. Talked to someone recently, and they said, we just finished a probate court process. 4 years for this family. 4 years, they said. The gentleman's grandfather passed away, and he said it cost $150,000 in legal fees, $150,000 in legal fees, and no names, of course, but he said the good side of the family doesn't talk to the bad side of the family any longer. So here you have $150,000 in legal fees, 4 years of painstaking probate process, and the family doesn't talk any longer. Terrible. All avoidable from my experience when families take action and work with a qualified estate elder law attorney to get the front side of the cloud, not the back side of the cloud, like that story I just shared with you. What if our friends Bill and Mary do nothing, okay? So let's take a look. Average cost, if they have a will or they have no will, which we call the government plan. Average cost of nursing homes in Mass Health are between $12,000. Average cost of nursing homes in Massachusetts are between $12,000 per month to $15,000 per month. Okay, so 12 to 15, depending on the nursing home, depending on the area that you live and so forth. So $12,000 to $15,000 per month, and they risk losing everything in as little as 18 months. So all the assets that we just added up, a little over $800,000, run the numbers, they could lose everything in about 18 months if they don't take any action. because they'll be private paying $12,000 to $15,000, Bill would have less assets for Mary. Okay, Bill private paying $12,000 to $15,000 for Bill, and then Mary is going to have less assets to live off of in the community, and she typically will have a substantial change in her lifestyle if this occurred this way. Solution now: purchase Medicaid compliant annuity to help Bill qualify for Medicaid benefits and do proper appropriate spend downs of the assets and increase income to Mary in the community to increase her quality of life. So what assets are considered countable? So I did a breakdown right here of Bill and Mary's assets, okay? Home. The home is jointly owned. Value is $450,000. Checking account, jointly owned. Value $50,000. Savings account. Bill owns that. Value $75,000. Automobile. They have one auto, jointly owned, $30,000. Stocks, Mary owns stocks, and her stocks are $75,000. And a CD is jointly owned, and that's value is $150,000. Okay. Also a tip, really important: asset transfers from Bill to Mary should qualify for what they call a spousal exception. Okay. In Medicaid rules, typically when you're giving money away, you're transferring is considered an impermissible transfer or a penalty. It will trigger a penalty period if you're giving money away to the children and the grandchildren. But it's okay to give money and transfer assets between spouses, called a spousal exemption or spousal exception rule. In this situation, what we would do here, because Bill is applying for Medicaid, Bill can only have less than $2,000, no more than $2,000 on the current Medicaid laws in his name and in his account. So anything in excess of that would be transferred, retitling that asset to wife Mary, okay, under the spousal exemption. Transfer everything over to Bill. Spousal exception rule. Then spend down amounts. Let's talk about spend down amounts. Mary can keep family home because the home is a non-countable asset for eligibility. Could be liened later, so keep an eye on that. She can keep one auto, furniture, personal property, and what they call the community spouse resource allowance. What is the community spouse resource allowance? Folks, that is the amount of money Mary's able to have in her name. Total maximum under current Medicaid laws, $128,640, okay? And we like to advise our clients, have no more than about $125,000 in the name of the community spouse, because you don't want any money coming in unexpectedly. Could be dividends, could be, I saw a life insurance policy once got liquidated, and it put the community spouse over asset. And if the community spouse is over asset, it's going to jeopardize the Medicaid benefits for the institutional spouse. So typically recommend play it safe, even though the community source resource allowance is $128,640 under current Medicaid laws. We typically recommend have no more than about $125,000 in the community spouse's name. In this situation, the community spouse is Mary, and Mary can hold up to $125,000, up to $128,640, but play it safe, about $125,000 in her name. So let's take a look at the total countable assets. Okay, total countable assets from the asset structure we talked about on the prior sheet is $350,000 when you add those up. They're countable assets. They're over asset, right? They're not going to get on Medicaid if we don't take some action. Mary's allowance is about $125,000, okay? $125,000 per the recommendation here. So we do the math here, and Bill's allowance is $2,000 per month, okay? So if we do the math here, we have a spend down amount of $223,000 right here. $223,000. Do the math. So we have to spend down $223,000 out of their total countable assets. And let's talk about how to do that. And there's some other permissible spend downs that you ought to be aware of. One right here is an irrevocable funeral contract. Each spouse can have what they call an irrevocable funeral contract. Work with your funeral director. They should be aware or familiar and have knowledge. It has to be irrevocable funeral contract. From my experience, under current law, you can have an irrevocable funeral contract up to about $15,000 per person or per spouse, okay? That's one way to spend down the estate to look to get on Medicaid benefits. Other permissible spend down is burial plot. It's about $1,500 for each burial plot. $15,000 for each irrevocable funeral contract. There's some other permissible spend downs as well. So long as Bill and Mary cannot be given money away to anybody else, okay? Because if they give money away to the children, grandchildren, neighbor, friend, that's going to be considered an impermissible transfer that will jeopardize their chances of getting Bill on Medicaid. Let's turn the page here, folks. Let's talk about the length of the Medicaid compliant annuity, Mary's age, and her life expectancy, okay? Mary's age was 73 years of age. Her life expectancy, according to the actuarial tables, is about 16 years, okay? Or divide that by 12 months in a year. Maximum Medicaid compliant annuity would be about 192 months. That's the max she can get. But then when you're working with your insurance professional or financial advisor, you want to talk to them about different strategies, longer term versus shorter term, what would be most appropriate for Mary in that situation. And typically in the industry, if Mary's in good health and she has longevity in her family and she can shift some of the monthly maintenance needs allowance rules under Medicaid, then she'd be looking at a longer term payout under the Medicaid compliant annuity. However, if Mary doesn't have all those markings right there, she might be looking for a shorter term payout. So let's say in our example here, Mary opts for a 24-month term. And when I ran the numbers with a $223,000 spend down that they need to do, they're going to take that $223,000 and invest in that Medicaid compliant annuity, okay? And that's going to give Mary 24 months of income at $9,320 per month in income to Mary, okay, from that Medicaid compliant annuity. So what they're doing, again, they're taking that $223,000 that they had that would have them over asset that would never qualify for Medicaid benefits. Under current law, they're able to convert that asset into income, into an income stream by purchasing and investing in what they call a Medicaid compliant annuity. And you want to work with your qualified financial people or qualified insurance professional or your elder law attorney who can refer you to someone who's familiar and qualified to guide you through this type of strategy. Again, folks, this is a Medicaid crisis planning strategy. All right, so back to $223,000 over 24 months will give Mary $9,320 per month, okay? They're gonna pay that $223,000 as a single premium, a total payout, and the caveat here, so in Massachusetts, Mass Health does have to be named as the beneficiary of that Medicaid compliant annuity. And we'll talk about that again in a moment. So Bill and Mary apply for Medicaid. Medicaid compliant annuity, Mary's income goes up from her $1,500 per month that she had originally. Now you add in her Medicaid compliant annuity, Mary's at $10,820 per month. She's living large. She's living better than she was. Her income went up, and that's okay under current Medicaid laws for Mary. Bill is now eligible for Medicaid because he took that $223,000 asset, converted it into a Medicaid compliant annuity income stream for Mary, the community spouse, okay? So Bill is now eligible for Medicaid, and his own copay is $1,727.20 to Medicaid because, go back to your notes, folks, Bill's original income was $1,800, okay? And he's allowed under current Medicaid laws what they call personal needs allowance. Personal needs allowance, $72.80 gets subtracted from Bill's original income. So that gives Bill a net of $1,727.20, okay? There's another caveat right here, disclaimer. Examples do not include other permissible medical deductions that oftentimes may be available as well. This is just a more simplified example to show you how a Medicaid compliant annuity would or could work in a Medicaid crisis planning strategy, okay? So here we go. So Mass Health benefit of Medicaid compliant annuity, and the maximum benefit of the Medicaid compliant annuity And Medicaid pay rate now would be private pay rate if $12,000 to $15,000 per month. Okay, folks, I want to point something out very important here in this scenario. Medicaid, or here in Massachusetts, Mass Health, MH, would be the beneficiary of the Medicaid compliant annuity. You might be thinking, hey Patrick, why even go through all this if Mass Health Medicaid is going to be, at the end of the day, the beneficiary of Mary's Medicaid compliant annuity? And this is the reason why, folks. This is where the big win would be realized, because Mass Health Medicaid, when they're paying for Bill's nursing home care, Mass Health Medicaid does not pay at the private pay rate. They're not going to pay the nursing home $12,000 or $15,000 per month, the private pay rate. They're going to pay at a lesser Medicaid contract rate, whatever that may be. Could be half, could be 2/3, maybe somewhere in that ballpark. That's just an estimate. So the end result would be the payout by Mass Health Medicaid is going to be a lesser amount, and then the payback to Mass Health is going to be at a lesser rate, a much lesser rate compared to if the family did nothing and they were private paying at the full rate for that 3-year period, we'll say hypothetically, for Bill. So you can run the numbers and you can see the difference, private pay rate versus Medicaid rate, end result savings for the family. Again, really, really important to run the numbers, work with a qualified elder law attorney and professionals to walk you through this process. All right, folks, we covered a lot of information here. The most important thing right here, take action. Take action, folks. Again, look at these statistical data. 70% of people 70 and over need some level of assisted living or nursing home care someday. The Medicaid course I sat in on recently, the statistical data was staggering. It said 35% of people aging in place will need nursing home care someday. 35%. Run the numbers. I gave you an illustration, an example with Bill and Mary, middle-class millionaires. They're not sitting on $1 million worth of cold cash, but their asset structure gets them up there, 800,000 plus. And if they don't take any action, they could lose the whole shebang, because when you run the private pay numbers at $15,000 per month over 36 months, that's $540,000 private paying for one spouse, okay? So folks, take action, work with a qualified estate planning and elder law attorney. They say knowledge is power, but knowledge is truly not power, folks, unless what? Unless you do something with that knowledge that you just learned. And I hope you got a lot out of this 3-part program, how to protect what you have from the 4-headed monster of estate planning and elder law. Folks, if you'd like to learn more, check out the book on Amazon, Patrick Kelleher, and get planning, get off the sidelines, take action, be that brave, courageous person in your family. When my dad ended up in a nursing home years ago, my dad was fearful. He didn't want to take his name off the family home. He never thought he would end up in a family home. And my mom was that brave, courageous person who took action to protect her why. And think about who your why is. This was my mom's why right here, her 7 cherubs. This is us when we were babies. I'm the little butterball, youngest of 7. And this was us, me and my 6 brothers, my 6 older brothers, at my dad's 80th birthday party many, many years ago. So this was my mom's why, my dad's why as well. But my mom took action. She didn't stand on the sidelines. She got on the field. She took action. And you need to do the same, folks. And if you love your family, take that personal responsibility. Give yourself that 30-day deadline. Put it on a calendar. Work with a qualified estate planning and elder law attorney and get the process started. Thanks for joining us, folks. We'll see you next time at elderlawcare.com.